Well, challenges to farm wills can often arise, with battles frequently involving farmland that's been held in the family for decades or perhaps even generations. Roger McEowen with the Washburn University School of Law joins us now for today's Rural Money segment. Roger, as always, thanks for taking the time to chat with us today. First of all, let's start with some of the basic will requirements. What are those?
Well, good to be with you, Janet. Well, every state has its own statutory requirements that a will has to satisfy in order to be recognized as valid in that particular state. So, for example, some of the big ones, it would include that the person making a will has to be of sound mind. So what that means is, and generally, you have to know the extent and nature of your property. You have to know who would be the natural recipients of those assets, and you have to know and be able to identify your relatives and be able to tell who is receiving the property under your will. That's how the law determines whether an individual has sound mind to execute a will.
So what does undue influence mean, and in what situations may it be present?
Well, it's often present when there's a confidential relationship between, say, a family member and the person that's making out their will. Undue is based on facts and circumstances, but again, it's often tied to the presence of a confidential relationship. And what the law does not want is someone else imposing their will on the decedent such that the decedent's will is no longer their own.
Do you have any examples for us, Roger?
Oh, the examples on this are legion, but there was certainly an interesting case that came up just a few weeks ago in Tennessee, where an individual executes a will, involves farm property, names his son as the recipient of his farm along with a nephew, and lo and behold, what happened? About 9 years later, his daughter begins to reestablish a relationship with him, so he then changes his will after he had suffered a stroke and left the property to her rather than the son. Well, you can imagine in situations like that, you've got one party that's totally disaffected by the new will, and so they challenge it and claim that the decedent did not have testamentary capacity at the time he executed the will. Long story short, he did. The court didn't find the presence of a confidential relationship. But these issues are always tricky, so we have to watch situations where there might have been a stroke, Alzheimer's, those types of things. It doesn't mean the person can't make out a will, but it means that if we catch them on a good day and they can identify their relatives and their property and who's going to get their property, that will is going to be valid.
Roger, what is the big takeaway here?
Well, I think the big takeaway is to be careful in these situations. Family fights over the farm are never a good thing, and sometimes the matter involves claims of undue influence or lack of testamentary capacity, and that can be the linchpin of an estate plan, that will. So care has to be taken to avoid situations that would arise that could lead to such claims.
Roger, as always, thank you very much for your insight this morning. We appreciate it. Roger McEowen, he's with the Washburn University School of Law, joining us on the phone today from Topeka, Kansas.